Welcome back. My guests will be Professor Ernest Kofi Abochi, Dean, UPSA Law School. Inus Afuseni is lawyer, former MP, Tamale Central, and former Minister Lands and Natural Resources, Roads and Highways. Gary Nemakomafo is Director Legal Affairs, the New Patriotic Party. Thank you all, gentlemen, for making time to join us on Newsfile. Gary, welcome.
Thank you, my brother. How are you?
I'm good. Thanks for asking. And let me begin by just reading a small portion of the OSP's report, the 25-page report to you, and then we will hear...
24.
It reflects in mine as 25.
Yes, sir.
Right. And here, the OSP at paragraph 3.1, that's where I'm beginning to read. It speaks about the referral. By correspondence dated the 2nd February 2, 2020, addressed to the Special Prosecutor, the Secretary to the President, Nana Bediato Asante, communicated that he had been directed by the President of the Republic to refer to the OSP allegations of bribery made against Ghanaian officials in an approved judgment of the Crown Court of Southwark in the United Kingdom delivered on the 31st of January 2020 by the Right Honourable Dame Victoria Sharp, the President of the Queen's Bench Division, in the matter titled Director of Serious Fraud Office versus Airbus SE, case number The 2nd February 2020 referral recounted that, according to the statement of facts, in the case between 2009 and 2015, a number of Airbus employees made or, and this is instructive, made or promised success-based commission payments of approximately 5 million euros to a person described as Intermediary 5, who was said to be a close relative of a high-ranking elected Ghanaian official described as Government Official 1. These are two important personalities in this matter. Intermediary 5, the former President John Mahama's brother, Samuel Adam Foster Mahama, and Government Official 1, identified as former President John Mahama. The referral narrated that significantly, the statement of facts stated that Government Official 1 was a key decision maker in respect of Government of Ghana aircraft orders, and that payments to Intermediary 5 by officials of Airbus SE were intended to induce or reward improper favor by Government Official 1 in respect of the purchase of 3 C-295 military transport aircraft. The referral also related that indeed, out of the 5 million euros promised to Intermediary 5, 3.8 million euros was paid between March 2012 and February 2014. At paragraph 4.1, on 31 January 2020, 3 courts, one each in the United States of America, the United Kingdom, and France, simultaneously delivered similar decisions containing agreed outcomes, variously described as consent agreement, deferred prosecution agreement, or judicial public interest agreement, depending on the jurisdiction, between Airbus SE and the relevant authorities in the 3 jurisdictions. The apparently coordinated judicial decisions impose global financial sanctions in excess of 3.9 billion euros on Airbus SE. The agreed judicial decisions were the outcome of joint investigations carried out by the Serious Fraud Office, SFO of the United Kingdom, and the French PACUER, is that it? National Financier, PNF, and a parallel investigation conducted by the United States Department of Justice, DOJ, DOJ and the United States Department of State, DOS, in respect of the alleged bribery and corruption and violations of the United States international traffic in arms regulation involving Airbus SE in Malaysia, Sri Lanka, Taiwan, Indonesia, China, Colombia, Nepal, South Korea, United Arab Emirates, Saudi Arabia, Russia, and Ghana. I read the very last one, then we proceed. The alleged bribery offenses of Airbus in respect of Ghana was investigated by the SFO, while the DOJ investigated violations by Airbus of parts 126.1, 129, and 130 of the law referred to earlier in the context of the alleged bribery offenses in relation to Ghana. Therefore, the judicial decisions by the courts in the United Kingdom and the United States affected Ghana. Consequently, the investigations carried out by the SFO and DOJ and the decisions of the two courts bear on the investigation by the OSP and thus require recourse in some detail. And those are the details that we will go into in the discussion, including the conclusion that no evidence of bribe paid to John Mahama was established. His brother was exonerated by the UK criminal investigations, and the OSP also takes the decision that he cannot proceed on a prosecution because there's no evidence. Welcome once again. Gentlemen joining us via Zoom, good morning once again. All right. Let's do this and return. Let's hear from John Mahama as he spoke to the press at Kimpensky. And then we hear from the OSP a brief of what he had to say to the Republic. We'll be right back.
The processes leading to the purchase by the government of Ghana of 3 C-295 twin turboprop military transport aircraft from Airbus followed substantially the same pattern. Parliament approved the proposed transactions in 2011. In accordance with the laws of Ghana, in the estimation of the OSP, there was nothing remarkable about the deal, and it certainly would not have found its way in the UK and US deferred prosecution agreements and made headlines around the world, but for the involvement of former President John Dramani Mahama and his younger brother of the full blood, Samuel Adam Foster, also known as Samuel Adam Mahama, and his associates, as recounted in the UK and US deferred prosecution agreements. The OSP investigation found no evidence that former President Mahama was involved or played any role in the procurement and maintenance of the agency relationship between Airbus and Foster and his associates in respect of the purchase by the government of Ghana of military transport aircraft from Airbus. And it appears to the OSP that the direct communications and meetings between former President Mahama and officials of Airbus to close the deal were actuated by good intentions on the part of the former president. It also appears that Foster and his associates became involved as intermediaries in the Airbus Ghana deal after the decision by the government of Ghana in preference of the C-295 aircraft. Therefore, it seems that Foster's Airbus intermediary role at the time his brother served as the vice president of Ghana was a case of luckless coincidence that attracted the disapproval of the UK and US authorities. The OSP found no evidence that suggests that the involvement of Foster as an intermediary of Airbus and the direct communications and meetings between former President Mahama and officials of Airbus to close the deal between Airbus and the government of Ghana amounted to any corruption and corruption-related offense in respect of which the OSP has a mandate. However, it ought reasonably to have occurred to former President Mahama and the government of Ghana that the familiar relationship between former President Mahama and Foster and the direct participation by former President Mahama in the communications and meetings with Airbus officials were bound to raise reasonable suspicions of improper conduct and dealings, notwithstanding any claims to good faith conduct and above-board dealings, especially in light of the fact that during the first Airbus campaign, former President Mahama was the chairman of the Armed Forces Council by reason of his position as the vice president, and therefore a very key decision maker. Such close proximity dealings by such elected high officials of the Republic and their kin, and close associates on behalf of the Republic, should neither be viewed favorably nor encouraged, as they give rise to reasonable suspicion of influence peddling and conflict of interest, never mind any intended good faith on the part of the vice president or the president.
Okay. I want to know how you would respond to your critics when they say that your corruption activities led to the Airbus scandal. Thank you.
A lot of allegations were thrown against me. I've been out of office for 7 years and 7 months. You think that if this government had anything they could stand on with how they hate my persona, they would not have prosecuted me for it. Airbus, the president referred it to the OSP, and the OSP is supposed to investigate it. You don't expect me to investigate myself. And so, if they had something to stand on, I'll not be standing here today. The same thing, hotel in Dubai. I challenged them. I said, let's go and find that hotel. I myself am in need of money. We'll find it, we'll sell it. You give me my small share, and government can take the rest. Till today, $10 million for diaries. President Akufo-Addo himself said it, that my government has spent $10 million to import diaries. They've been in office for 7.7 years. Where is the $10 million for diaries? And so I've challenged the MPP and the mudslinging and the lies they've told about me at every juncture to come up with proof of the allegations and prosecute me. I am an adherent of accountability. And I've said anybody who serves in public office should be prepared to be accountable. And that accountability must start with myself. And if they have any allegations that they could prove, they would have done so by now. It's just a political gimmick. When elections are coming, then they start raising all kinds of issues and all that kind of thing. But I remain focused. My commitment is to fight corruption. And if I come into office, I'll hold their administration to the high standard of accountability.
So you heard Special Prosecutor Kesi Ejabeng making that announcement that there is no evidence of corruption or bribery against President Mahama directly, and therefore the office has closed the dockets, closed the case on this matter. And earlier, the former president met with the press, and Parker Wilson asked him the question about the Airbus, and this was his response. Now, let's begin with my guest. Also joining us is Vitus Azim, anti-corruption campaigner and former executive director of the Ghana Integrity Initiative. Now, Gary, what do you make of the OSP's report that apparently brings this matter to a close?
Something. Good morning to you, and good morning to my senior, my brother, who I've not seen for a long time.
Come and join me.
He's looking very good.
Come and join me on the farm.
So I'm saying, let me state without any ambiguity that I agree with the findings of the OSP, but I disagree with its conclusion. And let me repeat. I agree with the findings of the OSP, but I disagree superfluously the conclusions that he came with. What are the facts? As you narrated, about 3 judicial bodies out of the jurisdiction have come into conclusion that Airbus have paid monies to intermediaries to induce or get business from officials in other countries, including Ghana. Airbus by themselves, with this unimpeachable evidence, approach the investigators, America, France, and UK. And they themselves agree and submit to judgment to avoid prosecution. If Airbus, in their view, were of the view that, in fact, the evidence as gathered was not what it is, they will have challenged the evidence before the judicial bodies. They didn't challenge it. They agreed. Having agreed to these positions, they paid fines to avoid prosecution. Now we are being told that Samuel Adam Mahama is saying that the monies he received were indeed commissions. They were legitimate monies. I disagree. If indeed these monies were legitimate monies, what were paid to him by Airbus, Airbus should not submit to judgment and say that, well, these monies that we paid to Samuel Mahama and other people were all not legitimate monies. Now, fast track forward.
2 questions before you fast track.
Yes.
Airbus agreed to these positions. As a lawyer, when you agree with your client to submit to a plea bargain, does that mean your client is actually guilty, in fact?
You see, Sammy.
We're educating the public. I just want you to help me with the education.
Yes, Sammy. Based on facts, material facts gathered by prosecution, and based on the law enforced, the law enforced in America, and this other jurisdiction was that once Airbus took the view that they were liable, they could take advantage of the plea bargain and submit to judgment. And that's exactly what they did.
We have the same thing in Ghana. You must have led some clients to do a plea bargain. I have done that before. Let's educate the public. When you submit to an agreement such as this, does it mean automatically that you are actually guilty?
I hold that view that yes, once you decide that you are liable, you don't want to contest the judgment, the findings of an investigator, then you are liable.
But is that the law?
That is the view I hold.
Okay.
That's the view I hold, because if indeed you think that you are not liable, you must contest it.
You know that businesses sometimes will look into the reportage and the consequences to their name by way of a criminal prosecution and decide to enter an agreement to avoid prosecution. And that, in fact, prosecution could fail.
Of course. Of course. But you see, look at this. Look at the material facts in this matter.
No, I'm just...
No.
I'm just asking you about the legal points for you to agree or disagree that this is what the law is.
It is possible that the business may consider its image and say, well, we don't want to drag our name in the mud, and so therefore want to enter into judgment.
That's correct.
To save our reputation.
That's correct.
And look at the material facts in this particular case.
Okay.
To the extent that in the first 2 aircraft, right, even when, you see, you're talking about thoughts, even when the deal had gone through and they realized that they could not pay someone other Mahama directly, okay, the Airbus officials set up, they made another company, a Spanish company, all right, use that company, pay the money to the company as a conduit for the money to be paid to Mahama, someone other Mahama. What was it for? You see,
so don't
truncate my thoughts.
This is my second preliminary question.
Okay.
This is not the major thing, so you can go ahead with your presentation. If what you are saying remains the law and the factual situation, Therefore, you disagree with the UK Serious Fraud Office investigations also, who say that they are unable to prosecute Samuel Adam Mahama and the other persons, even though Airbus submitted to this agreement and made the payment.
No, they said, the letter I read, they said they will not prosecute them because they were doing further investigation. And that their investigation have turned out that they cannot prosecute them. That's what they contained.
That's the point. They cannot prosecute them.
Yes, they cannot prosecute them.
At least in the meantime.
In the meantime, that is the letter. But you see, let me make the point so our viewers can really listen to what I'm saying. And I will come back a bit.
Okay.
Now,
you want to see his face?
I want to see his face. You see something. 2009, former President Mahama becomes Vice President of the Republic of Ghana. All of a sudden, we hear the name Samuel Adam Mahama surface, leading the charge for Airbus to do business for Airbus on this C-295 military aircraft. All of a sudden, at that time, they didn't occur to former President Mahama that the person leading the transaction for Airbus was indeed his blood brother, and that there could be potential or serious conflict of interest situations on the matter. It didn't occur to him that as Vice President of the Republic of Ghana, and then as by that reason, the chairman of Armed Forces Council, a key decision maker in the matter, and the person now leading directly these transactions in meetings in London, in email communications, in his offices, and all that, it didn't occur to him that potentially there was something untoward about these transactions.
The OSP raises that question, right?
That's the point I'm making. So, something.
So how do you agree with the finding but disagree with the conclusion?
This is the finding. I agree with the findings. It's the conclusion I disagree with.
So how do you disagree with the conclusion when the finding does not lead to...
The findings as they are contained in the report, all right, are at variance with the conclusion.
Establish that.
That is where I'm going. Don't truncate my thoughts.
I'm not truncating you. Go ahead.
Now, you see something? You have the Samuel Adam Mahama, okay? He being the blood brother of former President Mahama, leading the charge for this business. No other place other than Ghana. There were other countries which we were told that he was dealing with. And yet, they brought him to Ghana. And look at the aggressiveness with which Airbus was pursuing their business operations and offering monies and inducement and all that to officials of state. Fast track forward. We are now being told that this business actually went through. And then the first 2 aircrafts were signed. And Ghana paid for it. Why? We were expecting to see a direct bribery being given to Mahama, and then he carried the money direct to his brother in Ghana. Is that what we were expecting to see? I don't think so. You can never find in these transactions direct money being given to anybody. You can never find it. Okay. So it is the activities that you have to go around and look at the circumstances and look at the person's involvement. What was his interest? In being the Vice President of the Republic of Ghana, sitting in meeting in London, at the same time, being the Vice President of Ghana, entertaining these officials in his office, being copied in emails and communication and all that, or was he doing all these things? Directly doing all these things? That's how you look at it. But there is no way we can never find direct money being given to former President Mahama in this transaction. There's no way. In any event, there is a finding of fact by all the 3 jurisdictions that indeed monies were paid to Samuel Adam Mahama. And Airbus didn't dispute that fact.
Okay, so if I may ask a question without you saying I'm terminating your, truncating your thoughts. Do you realize that on the facts, Samuel Adam Mahama, whose employee was he? If you were to use the term employee, whose employee was he?
Airbus.
So he was an agent.
Loosely.
He was
Airbus.
an agent
yes,
for
loosely
them.
Airbus, yes.
Okay. He was dealing with how many other countries apart from Ghana?
Yeah, there were several countries. I mean,
About 11
Sri
in
Lanka,
total.
I see Sri Lanka, I see...
No, African countries.
African
About
countries.
11 in total.
Yes, yeah.
Correct? Correct?
Yes.
Good. So your point is that when John Mahama comes into government and then you use the terminology suddenly,
Yes.
are you being fair to the facts in that regard?
Why am I being fair to the facts? Why were there were other people, other agents of Airbus? Why is it that it's only him who was made to come to Ghana? Something. Read the report very well.
No,
you will see the aggressive.
Admitted.
No, you will see the
you
aggressive.
have just admitted.
Yes.
That Samuel Adam Mahama was an agent for Airbus and was doing business for them for at least 11 countries and or so many countries.
That is according to the investigation of the OSP.
So your statement that John Mahama comes into office and then suddenly he becomes someone who is working for Airbus for the aircraft is an unfair statement, it's an inaccurate statement,
because
correct?
at the time of the engagement, it was on the latter part of 2019. It is in the record.
No. If
2009.
If you hear my question.
Yes, 2009. That's what is contained here.
Your suggestion.
That is contained in the report. Read
Your suggestion was that his brother comes into government and then suddenly,
2009.
And suddenly he begins to front for Airbus for a business.
In Ghana, with Ghana. These are the facts contained in the report. Or you haven't read the report, something.
I take it that you don't understand my question.
What is your question?
Do you realize that when Airbus discovered the close relationships with the president, the vice president, or John Mahama, they did something. They terminated the contract.
The first one, which was flagged by Airbus internal, compliance, it was ignored.
No.
It's in the report.
Answer
The
in the
first
affirmative
one
or
was
in the negative.
Listen.
No, but you see,
the first one,
we need to be fair to the facts to our audience. And I don't want us to begin on this note. But
first one,
I just want to answer my question.
Did
Airbus terminate the contract when they discovered the relationship between the two?
That was terminated, but not.
Thank you.
But before, before Airbus internal compliance, all right, has seen this close familiar relationship, which was ignored.
What's the point?
The point is that Airbus internal people, they themselves realize the familiar relationship between the decision maker, the key decision maker, and his brother were meant to come to an interesting situation.
Okay,
but
I take it that you have not concluded your point yet. Continue to establish why you agree with the findings but disagree with the conclusion.
You see something. The point ought to be made that in such a situation where you are looking for a scenario of somebody being either in conflict of interest situation or somebody being suspected corruption or corruption-related offenses, you have to look at the whole circumstances. Because, for me, if I look at the timing, the time when Samuel Adam Mahama sought to engage the Republic of Ghana on these deals, it raises red flag. 2, the time that former President Mahama went to the United Kingdom to lead the business, the official business, for them to do a presentation for them. And he presented over the presentation when he knew that his brother was the person leading the transaction for Airbus. It raises red flag. The time that email communications, it was in copy.
Blind copy.
Over this same transaction, it raises red flags. The time that Airbus officials, and he admitted all these things, came into the country, went to his office on these same transactions, it raises red flags. He ought to have known that, as a matter of fact, it is my brother, my blood brother who is in the transaction. These are serious situations. Now, you do not expect, with all respect.
So the OSP should have done what? Should have concluded that there is basis for prosecution. Is that what you're saying?
There's a strong basis, in my view, to suggest conflict of interest situations, which
prosecution for conflict of interest. Is that what you're saying?
No. What I'm saying, conflict of interest situation, which should be referred to relevant authorities for them to look at it again. And in the issue of direct bribery.
Help me educate my.
Of direct bribery.
Help me educate.
I'm saying you cannot find direct bribery.
Okay.
You cannot find direct bribery.
Thank you.
But you can find suspicious activity. Because what was his interest in moving all these things? What was his interest?
You are saying that if you are the Attorney General, if you are the OSP, you will take this to court for corruption and corruption-related offenses.
It's difficult to take it to court. It's difficult to take it to court because you're not finding direct evidence. Even the circumstantial evidence is still difficult.
So what's the point of your disagreement with the OSP?
You can still see, something. Can't you yourself see traces or elements?
Help me to see it.
You can't see it.
I'm talking to you as a lawyer.
Something.
And with our training.
Something. You cannot see. Something. You cannot see.
With our training.
I'm asking you.
Corruption prosecution is a criminal prosecution. The burden is proof beyond all reasonable doubts. And you must not go with suspicion, because the Supreme Court says a multitude of suspicions cannot constitute proof. You know that. So if you agree with the finding and you disagree with the conclusion, and now I'm asking you to demonstrate your disagreement with the conclusion, and you say conflict of interest, but no corruption or direct payment of bribe, you cannot be saying you disagree with the OSP then.
Something. Look at paragraph 6.
Paragraph 6. Please forgive us and allow us to go through it this way methodically. There are other lawyers who are joining us. We'll hear from them.
Read the paragraph 6.5.
6.5. 6.5 says, and I read, the OSP investigation found no evidence that former President Mahama was involved or played any role in the procurement and maintenance of the agency relationship between Airbus and Foster and its associates in respect of the purchase by the government of Ghana of military transport aircraft from Airbus. And it appears to the OSP that the direct communications and meetings between former President Mahama and officials of Airbus to close the deal were actuated by good intentions on the part of the former.
I'm saying, what was, and I ask this question, the former president's interests in closing this deal when he knew or ought to have known that the person behind this deal or leading the transaction was his blood brother? Go to 6.6.
He says the procurement process. So the OSP has taken all the procurement documents, gone through all of it, and can't find the former president in there.
Are you aware that this procurement started...
Can't find Adam Mahama in there, but the Airbus and Ghana contracting. What do you want him to do?
Are you aware that this procurement process started even in Kufuor's time? It was only in Mills' time that they changed the brand of the aircraft. And all that time, these names were not there. And I'm saying that at the time they changed the brand of the aircraft to the Airbus, then you saw Adam Mahama surface and leading the transaction for Airbus. And I'm asking you a question. I'm not even asking you a question. I'm raising the question that it appears to the OSP that there's direct communication and meetings between the former President Mahama and officials of Airbus to close the deal were actually by good intention on the part of the former. And I'm asking a very important question here. What was the motive of the former president in closing this deal when he knew, or what to have known, that the person who was leading the transaction was his own blood brother?
Tell us about what the motive will be, because like Shakespeare says, there's no art to find the mind's construction in the face.
You see, something. That is why I'm saying that in some of these things, you look at the overall circumstances, all right? You can never find a direct transfer or convey of cash to somebody unless you look at the entire circumstance of the matter.
So what should the OSP do?
What should do? He has come out with this report.
Yes.
And we are about to critique the report.
Yes.
And make our input on the report.
Correct.
That's what we are doing.
Yes.
It's like a judgment of the court. So he has come out with his findings, how he sees it.
Not exactly a judgment of the courts.
No, I'm saying how he sees it.
The last time the OSP made something that was close to categorical statements on its investigations against Colonel Damois and others, the courts, scrapped that portion of the OSP statement.
Well,
so I suspect when I'm reading and I'm hearing the OSP say it seems, I think it is taking a cue from what the court has told it.
Well, so but you see where there has been definitive pronouncement by a court of competent jurisdiction in the UK and in the US and France on their findings of facts. I mean, forget about the fact that yes, they didn't involve the named parties. They were not involved in the investigation. Airbus took the whole liability and then
like vicarious liability, right?
Yeah, of course. I mean the whole liability and then pay the fines. That notwithstanding, I am saying that if indeed Airbus took the view that they can defend that action, or they could have defended that action, they will have done so. They will never have, in my view, all right, paid this huge money as compensation to these countries. That's the way I see it.
Thank you. Now hold on there. Oh, and I want to alert my guests, particularly the lawyers, that I will return to the issue that Gary just pointed out about the payments and whether or not they think that Ghana initially ought to have been active in seeking to benefit from those payments. Which could have been available, just like in the, ambulance trial that the state just lost, when Big C sought to pay almost all the money so that there would not be a trial, and then we didn't take it, and the case has been lost. We don't know what the Supreme Court will say anyway. So, Honorable Nusaf Hussaini, hold on for me. Mr. Abochi, thank you. Professor Abochi, thank you for your time. First of all, share with us your preliminary view of the OSP's decision, and let's know whether you stand in the place of Gary, that you agree with the findings, but you disagree with the conclusion, because according to Gary, even if you can't find crime, you can find some conflict of interest.
Well, thank you, Samson. First of all, we need to understand the fact that an investigation proceeds on a certain set of facts. And the investigation itself might have been started by a certain assumption. And the assumption could be that there's a suspicion that you're guilty of something. So we're looking for the facts to support the suspicion. I think the set point is OSP findings well, and the same measure the present standard of investigation that is. I would like that.
The line is not clear.
An important.
Prof, your line is very terrible. We will need you to reposition yourself or perhaps change the mode so that we can have you very clearly. We need you very clearly to settle certain issues. I have two politicians in the studio, and you know how politicians... And you know how politicians who are lawyers can interpret the law sometimes. So we can trust on you to help us in that direction. So please, let's have Abochi reposition. I know, you're a lawyer, but you're director legal of the NPP.
It is immaterial. You have two lawyers in the studio. Are you saying that by virtue of being politically, whatever it is, means our legal mind is jaundiced?
No, I haven't said that.
Yeah, so then I disagree with you to say that.
Thank you.
We are two lawyers,
okay.
Two lawyers in the studio.
All right, thank you. No, okay, so whilst we try to reconnect Abochi, I need a cleaner line to Abochi than what we are using now. Let me come to Nusaf Hussaini here. So, as he spoke, a lot of questions sprang up because of my training and I needed to ask him. But when you are doing this job, sometimes you have to avoid appearing to be interjecting him too often. So I didn't even, I stopped to avoid that impression. First, let me take your preliminary comments, and then I'll fly some of those questions by you.
Well, Samson, thank you so very much for having me. When the President Nana Addo Dankwa Akufo-Addo referred this matter to the OSP on the 2nd day of February 2020, I had occasion to appear on a sister network. And I told the network that this was a completely needless waste of time. Because if you read the UK judgment, the Suffolk judgment, read the American judgment, read the consent agreement of France, you will come to one conclusion, that these judgments contain exculpatory evidence against John Mahama. That should explain to you why the UK court did not pursue Samson Mahama and his associates. Adam Mahama. Samuel Adam Mahama and his associates. Two, you should be clear even from the beginning that this case was not grounded on bribery and corruption. It was grounded on unfair trade practices. A suit brought by Boeing against Airbus. Boeing had argued in these 3 jurisdictions that the activities of Airbus were giving them unfair and inappropriate advantage.
They seem to be getting all the contracts.
And so, by reason of the constitution of the agents and the way they played their game in Africa, Asia, and other places, they were violating the fair trade practices rules. So it was not a case brought against Samuel Adam Foster and his associate. No. It was not also a case, summato, raised by the courts against Airbus. It was Boeing that brought the issue against Boeing. That we should all understand that. 2, when Airbus detected that, well, it appeared to them that the Samuel Adam Mahama's involvement in Ghana's contract, could lead to certain breaches of the Fair Trade Practices Act, he terminated his contract.
Right.
He terminated his contract. John Dramani Mahama and all the Ghanaian officials had absolutely nothing to do with that.
And one of the facts that Gary ignores is, in his submission, is that Airbus had gotten its contract with Ghana even before its agent, Samuel Adam Mahama, got into the picture. Right.
Yeah, it's very important. And so, when you look at the case clearly, and Gary, probably you should agree with the conclusions of the OSP. Why? Because you say you agree with the findings. The OSP and all OSPs have specific mandate. Specific. Immediately they establish an office of a special prosecutor. He's given a specific mandate. He can't go on a frolic of his own. And if, in your view, the case did not lend itself to bribery and corruption, but something else.
Conflict of interest.
You didn't expect the OSP to say anything otherwise.
But the OSP is known to have suggested other things.
Well,
when the OSP exonerated Edu Boahen,
yes,
the OSP said that what he was doing amounted to, is it influence peddling? Correct? Yes.
Influence peddling.
And maybe somebody else could take care of that.
Maybe somebody else, not him.
Cecilia Dapa.
He said that was more of money laundering. So
exactly, someone else could do that. Yeah. So Gary is simply saying, by that measure, by that standard, the OSP could say there seems to be conflict of interest. So maybe, so there was conflict of interest. So Shraj should take it up.
Yes. What Gary is saying is not in tandem with the law that set up the Office of the Special Prosecutor. The law did not say that if the Office of the Special Prosecutor came to a conclusion that its jurisdiction in the matter had not been properly invoked, it could suggest other institutions to take up. The law did not give the Office of the Special Prosecutor that mandate. Now, what the mandate the law gave to the Special Prosecutor was to request for cases. I mean, that's the opposite. If the Yoko or Chirac was investigating a matter and the Office of the Special Prosecutor felt strongly that that matter bordered on its jurisdiction and it could do the case properly so well, it could call for that case and do it, but not suggest where the case should go. Now, so the conclusions, in fact, to be honest with you, I would have been shocked if the OSP had come to a different conclusion. Unless you've not read the judgments, the deferred prosecution judgment or agreement of the UK, the consent of France, and if you read all.
Before I go to Abochi, you hear the argument that is coming up, particularly from the NPP. They are saying the OSP did a lazy job. And this is their point. Among their points, the major point, is that how could all these three countries, US, UK, and France, enter judgments so-called, and the people submit to it, and you come to tell us here in Ghana that there was nothing wrong?
So you must look at the case the UK, France, and USA were investigating. The referral letter from the president to the OSP said he should investigate instances of corruption, bribery. Were those matters that these courts or these countries were investigating? Were they?
To a large extent, these countries, the conclusion was that some bribery had gone on, and Airbus had done nothing about them, even though it had control over these officials.
The conclusions of the three courts was that the monies that were paid to Samuel Adam Foster were intended to bribe. Were those intentions realized? Were they effectuated? Were they carried through? The OSP and even the British court says no. We didn't see any evidence. There's no evidential proof that monies moved from Samuel Adam Foster or Mahama to John Mahama or any public official who was connected with the transaction, I mean, directly or indirectly. They didn't see any evidence.
Gary is asking you the question. Corruption happens in darkness.
Yes.
Are you expecting to see that money directly came from the brother to the brother?
I'm expecting to see that Adam Mahama, if the UK courts had reasonably believed that those monies were not agency fees, but were monies intended for bribes. Bribery is a criminal offense in the UK, it's a criminal offense in the USA, it's a criminal offense in France. I was expecting to see that if the UK courts, where Adam Mahama is resident, had reasons to believe that those monies were intended for bribes.
It's resident and citizen.
And citizen, they would have prosecuted him.
Okay, hold on there. Professor Abochi, thank you very much. I've spoken to the two lawyers, the two lawyer politicians, without intending any prejudice, please. So, first, tell us your reading of the report and in summary, what you make of the report.
Well, as I indicated, I think the special prosecutor had a mandate. In my opinion, the report is fair within the context of the fact that he sought to investigate. from the totality of the discussion that I followed so far, I think it's important for us to distinguish one very important thing, and that is the fact that we need to separate the perception of corruption from the actuality of corruption. In the context of the actuality of corruption, anybody who alleges that there is, in the context of the actuality of conflict of interest, anybody who alleges that there is a situation of conflict of interest must provide a factual basis that supports the allegation. Now, where it is established or proven, a person against whom conflict of interest is alleged, that person is valid institution, it's the public, and a high value. In the of the perception of corruption, right? The mere perception of self, and where there's a perception, right, problematic.
Professor Bochi, your line started very clean, but it's getting bad again in a way that we can't hear you. And we need to hear what you articulate because it's very important. So if you may indulge us, we know you are busy, and but if you can agree to do this via Zoom, I suppose that may be better. Thank you very much, Professor Bochi, and we'll get to Professor Bochi shortly. Vitus Azim is on the line. Thank you, Mr. Azim. As an anti-corruption crusader over many years, having led the Ghana Integrity Initiative also, what do you say about the OSP's report?
Well, I want to say that we're in a democracy and we have set up appropriate institutions to deal with relevant issues and enforcement of the law. And so we may have our reservations, we may criticize the heads of those institutions, but when they come out with their report, we have no choice than to accept it. If we don't accept it, and there's an escalation of the matter with the highest body, then we go up there. So for now, I think unless there is somebody who doesn't agree with the point and wants to take it up with a different authority, the matter has been brought to an end. This investigation has taken about 5 years. It started with the first public prosecutor, special prosecutor, and then he did not take any findings. Then this man, took over. And still, he says that he cannot get a clear evidence of a direct involvement, not involvement, but in the Corruption Act by President Mahama and even his brother. In the first place, we don't even know who brought in Samuel Mahama into this transaction. Was it the government of Ghana or it was him? Because I heard one of the panelists said he's resident in Africa. So is it not possible that he has breaking with Airbus, even in the past before this transaction? But having said that, the report says that even the government of what is former President John Mahama, they have not found anything untoward in his involvement in the transaction. As the Vice President or the President, he had a role to play in this transaction. But did he do anything untoward? Did he receive money as a result of this contract? Or did he receive money in respect of this contract? Did he benefit personally or indirectly as a result of this transaction? The special prosecutor has not been established. And in the past, I have said that the present special prosecutor loses in most of his cases because he's not able to build a docket before proceeding to court. And so if he has found that he doesn't have enough evidence to prosecute the matter, I think he should go to a conclusion unless an agreed person wants to a different authority. With regards to the conflict of interest, I am happy that he cautioned all public officials about this conflict of interest. You see, there are three aspects of conflict of interest that politicians should be worried about. The actual conflict where it has started to place, maybe there are people or the transaction was the cause of relations and all financial. There's also the potential conflict. The fact that you are giving this contract to your brother, how well are you providing more here?
Sorry, Mr. Azim, can we stick to the facts? When you say you are giving a contract to your brother, are you referring to this case?
No, I said I'm happy that the special prosecutor cautioned public officers about conflict of interest. Before going on to say that, I'm not saying that he gave his contract, the contract to his brother, but I'm just giving an example. Or you can say it to your daughter. So the potential one is because of that relation, it's possible that the transaction will not be transparent and may not bring value for money to the country. But the most dangerous part for me is the perceived conflict of interest. Whether there's conflict of interest or not, whether you have done anything on authority to Airbus or not, the public, the Ghanaian politicians, the Ghanaian people see it as conflict of interest. And that's dangerous for a politician.
Right. So
I welcome
Gary,
his caution.
Yeah. So Gary just raised something in that direction without exactly stating it, so that now we are being told about Dr. Mahmoud Bawumia's brother getting certain contracts. We are being told about the cousin, what do you call them? Did I say cousin? Yeah. Gabi Asarechire Dako getting contracts, at least the Ejapa, deal. We knew that his firm was one of the lawyers. And there are fingers being pointed at associates and family of the president getting certain contracts. Is it fair to just conclude that because they have a relationship with the president or somebody in government, then the contract is not above board and everything else is bad? Is that the situation?
It would definitely be unfair to jump to that conclusion. And that's why we have a Public Procurement Act, 663 and its amendment. You now go back to the Public Procurement Act. Was it competitive bidding or sole sourcing? If it was competitive bidding, was the person the best candidate? If it's sole sourcing, was the person justified? Was there enough justification for that decision? And did the Public Procurement Authority authorize you to do sole sourcing? So it's not just one approach. We look at the other things. Of course, I've heard people say, oh, but are you saying that if my brother or even a daughter of the president, I cannot benefit from the public sector? Of course, in this country, most contracts are awarded by the government. So maybe it's not possible.
But I thought those of you in the anti-corruption, campaign space, you would have agreed with Gary, because corruption is done in darkness. And if you are looking to see in the procurement documentation that there was some direct influence by the people in power whose relations, politically exposed persons, got that contract, you will never find any. And therefore, perhaps you should just give up on the corruption fight, the grand corruption fight.
No, I think you can find it. If you do due diligence. That's why I said we have the Public Procurement Act to guide us. You need to go back and look at it. And you see, for every transaction, there is a paper trail which you can follow. Checks are written, board meetings or procurement committee meetings, decisions are written, are decided on, are documented, and then letters are written. And so there are usually, if it's competitive, there are usually assessments for the project and all that. So if only you want to do a good specification, there is a paper trail that you can use. to trace this thing.
Okay.
And you see, I've said that if you say, oh, because we cannot fight corruption, you should just forget about it. Then are we saying that this country can just go to the dogs and we don't care? We'll just hold our hands and say that look, it may be difficult to fight corruption.
Okay.
It is important that we fight corruption. The fact that we're talking about these issues is enough.
Yeah. Thank you, but there's this interruption in your line. I don't know what it is. Let me go to Prof. Abochi now and hope that we have a clean line to him. Prof, kindly start what you began to tell us. Hello, Prof. Abochi. Please unmute your mic and tell us your view or your reading of the report.
Okay, can you hear me now?
Very clean, thank you.
Okay, so I'm sorry about the difficulty. The point I was making was it is important at the outset to distinguish between the actuality of conflict and the perception of conflict. The consequences are different, and too often we tend to blend them. Now, in terms of the perception of conflict, you're dealing not with a conflict situation that has actually arisen, but you're dealing with a set of facts that create a perception, that creates a suspicion that there may be conflict having arisen. And then you have the actuality of conflict. What the law prohibits in the four is the actuality of conflict. And in the terms of the actuality of conflict, a person alleging that there has been conflict has to provide the factual basis supporting the allegation of conflict. And the factual basis here implies the fact that there is a relationship between a decision maker and a beneficiary of the decision. And the decision maker's relationship with the beneficiary of the decision is of such a material character that the beneficiary of the decision maker has benefited or would benefit from making that decision. So in terms of the perception of conflict, the law doesn't, so to speak, ordinarily prohibit it, but the law counsels against it. And so, for example, if a person who has a decision-making authority engages in an act which is deemed or could be deemed to create a conflict situation, that raises ethical issues, that raises officialdom issues, and other issues that, as it were, undermines the authority reposed in that person as a public official to take that decision. So when it comes to perception of conflict, the key and the most important thing in prohibiting the perception of conflict are the issues of disclosures. And so one has to disclose, for example, the relationship that he has with someone who stands to benefit from a decision that is being taken. Now, having made this point, and in the context of the investigation, it is important for us to also remember, and I think Mr. Vitus Azim made a statement that may be closely related to this. It is important for us to remember that holders of public office have relations, and those relations have agencies. In other words, they have relations who are autonomous and who do not take instructions, so to speak, from the holders of public office. So what it means is that those relations can ordinarily do all kinds of things that ordinary people do, including bidding for contracts from the states. It is also therefore the reason why we have strictures or we have limitations placed by law in the exercise of these powers, including procurement powers of states. So the most important thing is, if you have the relation of the former president bidding for state contracts, the former president cannot, by law, prohibit his brother from bidding for state contracts. What the former president can do, of course, is to do his possible best to distance himself from the transaction as much as he could. There are circumstances where he can't because the law mandates that he takes certain decisions. And so for those ones, he would have to take the decisions. But where he could, he distances himself as much as he can. Number two, appropriate disclosures. If, for example, the contract would have to go to Parliament, if the contract would have to go to any other body for consideration for the matter, what the former president can do is to disclose. But even more crucially, what the beneficiary of the contract can do is also to indulge in appropriate disclosures. But beyond these, the former president cannot of himself prevent somebody who's of full age and capacity and who has agency and autonomy from participating in state benefits that the person ordinarily has entitlements to participate in. One other difficulty for this particular contract, and which is perhaps why the OSP's conclusion is what it is because it is a specialized area of contract. It is not an ordinary commercial contract. You're dealing with the procurement of aircraft or aircraft spare parts. There are few entities in the world that are in those areas. And what that means is that in terms of procurement, you are not likely to get many entities even bidding for this. So as to whether or not the state could have decided that within a range of options, the state is abandoning a particular bidder and going for another bidder. And the reason being that that bidder has a relationship with the president, for example. As to whether the state had that choice. The dynamics in this particular circumstance will not be the same if, for example, the state was going out there to buy, say, textbooks for students in secondary schools or universities. So some of these things can create complications. And while, therefore, conflict of interest is something that has undermined Ghana in many ways for many, many years, it is important to also have the nuances clarified. And those nuances must reflect in the discussion so that we do not ask for a jump.
Okay, so the discussion is getting to turn on conflict of interest. But first, establish some legal principles for me from where you sit, your many years of practice at the law, teaching the law, and training people in this area. When you do the agreements that these countries did with Airbus, does it mean automatically that you are guilty of an offense?
I suppose you are speaking of plea bargaining?
These were deferred prosecution agreements, consent agreements, and whatever agreement. They are in the nature of plea bargain.
These agreements have different nuances in the jurisdictions in which they are made. So, for example, in America, they have another one they call the no contest plea, where you basically plead not to fight the case, so to speak. In my understanding, and respectfully to my colleagues, these agreements do not amount to an admission of guilt. These agreements are statements of a person who signs them that I'm not going to go through the process of litigation. I'm not going to go through the process of the proceedings. And the fundamental statement made here is that I'm not going to take my chances in respect of the jeopardy of criminal proceedings. Now, it's important for you to understand that criminal proceedings ordinarily create jeopardic consequences. And that's why in criminal proceedings, something they call double jeopardy. If you go through the trial twice.
Why will a business like Airbus, that has all the money, can hire the best of lawyers in town, decide to settle rather than get the best of lawyers to fight the case and win it?
Proceedings and criminal proceedings have dangerous commercial consequences for big companies. Companies will have to make calculations and do the cost-benefit analysis of whether it makes sense to fight or it makes sense to settle. Now, in settling, the fear may not be one of they feeling that they're guilty, but because criminal proceedings may entail these consequences that may affect their commercial bottom line. One of them could be the fact that there may be some disclosures and there may be some discoveries and other criminal compulsions that may be incumbent on them, and that may result in they having to make disclosures they do not want to make or undertake, for example. And some of them could be pricing, some of them could be persons they've dealt with, commercial partners, trade secrets, all kinds of things that may impact their commercial bottom line. And so they do considerations and calculations, and they come to a conclusion that it is more commercially sensible to just settle, not necessarily admitting that we're guilty, but admitting on the basis of whatever the plea is. And some of them could be, as I said, no contest. No contest indicating the fact that we're not fighting it. We do not admit guilt, but we're not fighting it. And we're not fighting it, and we're going to pay for whatever consequences there are. I think recently we had a similar scenario with COVID in the United States that is popular, that everyone might have heard about. So these agreements do not necessarily amount to an admission of guilt, but there may be collateral consequences and loss, especially for companies, for going through the process.
Right.
And they make the cost-benefit analysis of this, and they come to a conclusion that it makes more sense to, as it were, just close it by admitting something and then moving on instead of fighting the process.
Right. Now, there's an interesting angle I want to raise, beginning with you, that they got in excess of, is it $3 billion United States dollars in these settlements. the various countries that these things were said to have been done against, the position is that will or have benefited from this payment, except Ghana. Do you see that there was a possibility for Ghana at the very start, either to focus on getting some of the money or keep a dual focus, that we get something and then whilst we pursue the criminal prosecution as well? And I understand that that would have been done by the OSP working with the Attorney General's department, like the other countries also did.
Well, I have to confess to you that I haven't thoroughly followed their foreign proceedings, so I'm not exactly aware of some of the outcomes like you're mentioning. But yes, a country has to make calculations, in criminal, not just in criminal, but in civil proceedings as well. There's something called mitigation of losses, usually in civil proceedings, and mitigation of losses or cutting your losses. It's a legal remedy which makes it incumbent on a party who, while entitled to make certain claims, can decide to cut his losses by ensuring that whatever he can save, or as much as he can save, he saves that. So indeed, it could have been open to Ghana to have made that claim if the option was available. As I indicated, I really haven't followed thoroughly, so I can't make those factual statements. But yes, if other countries have made those claims and they have received certain payouts, and if the factual circumstances in terms of Ghana are similar, then of course Ghana could have pursued that. The United States is a common law country, and therefore substantially our legal principles are similar. My expectation is that the mitigation of losses and the cutting back on losses in proceedings in which parties are allowed to make certain claims in lieu of other proceedings. I expect that in the US that must have been available, and therefore Ghana could have taken those chances again if the factual circumstances were open, given that I really haven't followed.
This is a redacted report, which means there are certain things that have been hidden from us that we do not know. And I can understand if you are dealing with the US State Department, if you are dealing with the UK SFO, if you are dealing with Airbus, as we understand that they made contact with all of these entities, including Airbus itself, except that Airbus declined on some very good reasons for them, that they have submitted to this judgment and there are conditions to what they have submitted to. So they were not willing to participate any further with anybody else who wanted to do anything. Apart from, if they had access, you have access to the judgment, you simply use it. But do you agree with the special prosecutor, and people are raising issue with this, when he says that, I read from paragraph 5.2. Okay, so paragraph 5.0 going. OSP investigations. Notwithstanding the definitive pronouncement by the UK and the US courts on the accepted culpability of Airbus beyond reasonable doubt for bribery in relation to the sale to Ghana of C-295 aircraft, it was imperative that criminal investigations be carried out by relevant Ghanaian authorities for several reasons. First, the relevant investigative authorities in Ghana did not participate in the investigations in relation to the acts that refer to Ghana. The President's 2nd February 2020 referral to the OSP is testament that Ghana officially became aware of the global investigations into the conduct of Airbus by the SFO, the DOJ, and DOS, and the PNF after the fact and after the coordinated 31st January 2020 judicial pronouncement. Here is the explanation the OSP gives. The UK and the US judicial decisions only establish criminal culpability in the context of the laws of the two jurisdictions. It does not automatically follow that the acts accepted as proved beyond reasonable doubt in those jurisdictions amount to criminal offenses in the reckoning of Ghanaian law. To rely solely on the UK and US decisions without more as proof of criminal culpability would be akin to seeking to enforce the criminal laws of the UK and the US in Ghana, which is impermissible. Therefore, the UK and US court decisions cannot of themselves be of the only index of proof of criminality in Ghana. That is to say, the Republic cannot hope to successfully mount criminal prosecution solely on the back of the two foreign court decisions. It has to be shown beyond reasonable doubt that the acts amounted to criminal offenses in Ghana. He says again that the above detailed account of the outcome of the investigations and court decisions in the UK and US shows that the deferred prosecution agreements did not include and cover the reference individuals. The agreed settlements were reached by the UK and US authorities with Airbus only. Indeed, the UK court stated in paragraph 6 of its decision that the deferred prosecution agreements provided a mechanism by which an organization, being a body corporate, a partnership or an unincorporated association, but not an individual, can avoid prosecution for certain economic offenses through an agreement with the prosecuting authority. Similarly, the US DPA, that's Deferred Prosecution Agreement regime, provides no prosecution against protection against prosecution of any individual regardless of their affiliation with Airbus. Finally, it seems that Airbus accepted criminal culpability for bribery for itself and also vicariously on behalf of the reference individuals, including its employees, agents, business partners, and Ghanaian officials, and that the reference individuals appeared not to have been direct subjects of the investigation by the UK and US authorities and were not afforded opportunity, if they were so minded, to take it, to explain their actions, and to present exculpating evidence, if any. Do you agree?
Well, these are strict matters of law, so it's not even subject to an opinion. And the principles are these. Number one, foreign judgments are not automatically applicable in Ghana. For foreign judgments to be applicable in Ghana, like many other jurisdictions, usually they are regulated by what is called Mutual Recognition of Judgment and Enforcement of Judgment Acts. In Ghana, I'm certainly not aware, but I'm not aware there's a recognition of judgment between, say, Ghana and the US courts. What that means is that in the absence of such recognition and enforcement of judgment, a foreign judgment in Ghana is only as good as, one, an allegation outside of courts, and two, evidence when led in court or exhibited in the proceedings, or in particular in criminal proceedings or civil proceedings. When so exhibited, and
Did you lose Professor Bochi? I think we lost him, but I suppose that will be sufficient for now. Thank you very much, Professor Bochi. Unless it is very necessary that you make any further commentary briefly. You are back. Hello, Professor Bochi.
Can you hear me?
Okay, we lost you.
Can you hear me?
Yes, we lost you. We can hear you now.
Right.
We can hear you. Okay.
So the point, just to wrap up on this, but the point I was making was, unless it is led in evidence and then ultimately admit. Can you hear me?
Please go ahead. Yes.
Can you hear me?
Yes, please.
Something. Can you hear me? Okay. So I said unless it is led in evidence, mere allegations. And so what that means is that typically typically you can't use the foreign judgment against a person whose name is mentioned in there, more particularly so when he was in a party. It's strictly correct for me. It's an allegation, it's a foreign decision, it has no application here. The parties affected were not parties, or the parties mentioned were not parties to the proceedings, and therefore they did not have the benefit of contesting it. In the circumstances, it cannot be used as though it is binding on the Ghanaian investigative body or authority to use it in the manner in which judge.
All right.
Typically used.
Sabochi, unfortunately, as you are concluding, your line is becoming very bad. Thank you very much. Professor Abochi will take leave of us. I come to the studio for brief comments before we, as it were, close the chapter on this discussion and go to the apology rendered by the finance minister, and some saying it's a non-apology, it shouldn't be accepted. So what should we do? We should accept it, but do what? Some say apology, so what? After the apology, what? They don't see anything being done in the government that suggests that the apology ought to be accepted. Well, okay, so your very final comments. Yusuf Hussaini, don't you agree with Gary? In criminal law, you can also use what is known as circumstantial evidence, except that the law's requirement is that circumstantial evidence must point to one and only one. If it gives room to some other, conclusion, it will not be relied on.
And if you are in the Republic, circumstantial evidence must lead irresistibly to one conclusion. In this particular case, what conclusion is it going to lead to? His brother.
No, the brother is the vice president or president. Therefore, if he received money intended, and we haven't seen any connections that he got money, he must have gotten money.
Circumstantial evidence must lead irresistibly.
It's presiding over all the meetings.
It must lead irresistibly to the fact that money did pass.
All right.
And you can see they must be. No, you can see issues. I mean, those who are closer, I mean, you stated the law, and I'm just saying that the law is very stringent, and that you can't use circumstantial evidence unless it leads irresistibly to one conclusion. And in this case, it won't lead to that conclusion. Two, in fact, talking about conflict of interest, you need the GRUNO in our jurisdiction is Article 284. And to say that the former president has put himself in the conflict of interest situation
by presiding over all the meetings.
No. Whilst he was,
he's not presiding.
And I think when you say all the meetings, you may also be
not even presiding.
No, that he was in a certain official position.
Yes.
And he was the one charged with overseeing the aircraft process from the presidency.
Yes.
Okay, go.
Yes. And so,
and the chairman of the council.
So 284 requires that proximity, that familiar relationship that existed, that is likely to lead to a conflict of interest situation, must affect the performance of the president's functions of office. It's not just saying that he said, it must, and how does it do it? Did he vary obviate the need for a decision or due diligence or a step or a motion to be taken in favor of his brother? Did he do that? The special prosecutor answers it neatly. He provides a chronology of what happens when the military is to take a decision to buy hardware. It means that everything that was required to be done under the circumstances was followed to the letter. How do you establish a conflict? Conflict of interest is not just saying, Sala and the Attorney General should bring your mind to the requirement of conflict of interest. It's just the fact that me and Samson, we come from the north.
You're talking about bias.
Bias.
Yeah.
Yes.
Of course, it comes with
the conflict of interest. That is affecting the functions of the office. It's being biased in favor of that person. And you don't see it in this matter.
But
what
do
happens,
you
Samson?
agree with the OSP's advice? Whether it was a luckless coincidence or whatever it was, do you agree? The conflict of interest rules require disclosure. If you promptly do a disclosure, you immune yourself from the problems.
The special prosecutor, and I agree with his advice, and I have since the matters broke, I've spoken with many people, and their advice and our conclusions tie in neatly with the advice of the special prosecutor. As a country, we must do very well to insulate the presidency or the president and the vice president in matters of this nature, in commercial activities. I mean, everything leads to back to the presidency. Everything leads to the vice president. I mean, I have heard in your government, people tell me that if you want something done, you must, by all means, see the president. It should not be the case.
Or you should see Gabi.
Or you should see, no, Gabi is not the president. If you see that, you know, that is the because Gabi will go and see the president. Which as a country,
is not here to debunk that allegation.
No, I'm not saying, that's why I've said Gabi is not the president.
No, Gabi has admitted in Manasseh's book of his influence because of his proximity to the presidency, even though it's unofficial.
Yes.
Yeah.
That's the problem. So we agree. I mean, I spoke to a very senior person in the party, and he told me, look, sir, after my interview, sir, it's true. Next time, we must protect the president. He mustn't be seen to be engaged, even with good intentions. Because you can see what happens, Samson, if you are sitting in this studio, then a brother from Mirugu or Sirigu comes here, and then you are in the position of employing people in this establishment. Do you say that, well, because you are from the same town with me, you cannot take part in the interview? Do you say that? What you have to do is to put in institutional mechanisms so as not to give him unfair advantage over his colleagues. And that is what the former president.
And you know what you just said?
Yes.
It gets people to dislike you.
Yes.
There are people who make contact with me. I'm no politician. Some of you finish this show and they are standing around the place looking for you. They are following you all over the place, asking for jobs, immigration, police, and the rest. I am no politician, but I get the same requests coming to me. And sometimes, not sometimes, almost all the time, I begin with the caveat that I don't do this. Oh, but you know Gary. Gary is legal affairs.
And we're all here.
We can get to here. Yes. You know Abu Jinapor, what I'm looking for is within the forestry place. You know Kokofu, you know this. My own blood sister spoke to me about connecting to somebody who was, because of her job. And I said, I can't help you. But your family will not like you because you're saying these things.
Exactly. So what happens? That's why Salah and Attorney General should guide us in this discussion. What happens? And so that's why I feel, so anytime this case comes up, the former president has been greatly distressed. Greatly and sad. Because he did absolutely nothing. He lost his brother when his brother of his was 9 or 10 years. He was taken to the United Kingdom. Did not see him. He was engaged in other activities. Before former president became vice president, he was actually constituted as an agent of Airbus before he became vice president. Suddenly he appears leading. What do? You say, my brother.
2009.
My brother, I mean, even though you were under before you were leading this thing, and not me, I'm president, so you can't. What do? So you see the trauma that we have put the former president through. All he did was to ensure that all the motions were followed. All the motions.
Because that was his responsibility?
Yes. And if the motions are followed, and go back and look at what the former housing minister under Kufo, look at how I forgotten his name. He has said, look, our brothers do eat. So when they come to us, all that we have to do is to ensure that we don't flout the laws in their favor.
Okay.
Now, so let me just conclude on these two things. So it's true, criminal law is jurisdictional. It's not extraterritorial. So if a person is charged with an offense, it doesn't automatically mean that Ghana can take it up. No. You must either find that offense in Ghana or you must lead that evidence as fact. The judgment becomes a question of fact in court. 3, we must also know that if you could not establish bribery and corruption,
it must be stated the principle of law that the judgment could be used as evidence in a court of law.
Yes.
Right.
As a question of fact.
Yes.
Yes.
Correct.
Now, again, in criminal jurisprudence, you can't infer the criminal conduct of a person. You don't infer from A, B, C, D. No. There's criminal conduct. You must see criminal conduct. Because
mens rea, actus reus, 2 important things.
It must be there. You can't infer.
That there was the mind,
so
criminal
the
mind,
fact that you are saying that you can look at
the actual
you look at all the, you can't infer criminal. The third thing is that, I think that this matter has been brought to a close. The Nana Akufo-Addo has established, and I've said it on your studio here, has established a precedent. I have always said that when you read the Constitution doesn't say that a certain person cannot be investigated. Only says that you cannot be prosecuted. Now, it's a former president who has been investigated. I'm looking to our intelligence agencies, our security agencies, to grip their loins and investigate certain presidents.
I've heard people who are applauding the OSP for doing the first and doing a very great, bold job.
I have said it over and over again. If you read the Constitution, nowhere in the Constitution has it insulated a sitting president against investigation.
So now there's precedent going forward.
Going forward.
Okay. Yes.
Yeah, Samson, I listened to Professor Buchi. They kept saying may. And I think we should put the thing in context. The foreign court made definitive pronouncements. He was not going may. You know, I said the monies were paid, okay, to increase sales. And the monies were meant for persons to take advantage of certain persons intended to obtain or retain business or an advantage or in the conduct of Airbus business. These were definite pronouncements made by the court. And that those financial advantages were intended to reward such improper performance, and further that Airbus did not prevent or have in place at that material time adequate procedures designed to prevent those persons associated with Airbus from carrying out such conduct.
Right.
Now, before I conclude, respectfully, if you may read paragraph 4.4, 4.5, 4.39, and 4.0 together, and I'll just sum it up. 4.4.
4.4 says that it is well known that on the 31st of January 2020, the President of the Queen's Bench Division, the Right Honorable, that's like Godfrey Dami, the Right Honorable Dami Victoria Sharp, sitting in the Crown Court at Southwark, delivered a final declaration and order in respect of a deferred prosecution agreement, DPA, between the SFO and Airbus in the case of Director of Serious Fraud Office versus Airbus, SC. This was based on the investigation conducted by the SFO in respect of Malaysia, Sri Lanka, Taiwan, Ghana, which was held to demonstrate that in order to increase sales, persons who perform services for and on behalf of Airbus offered, promised, or gave financial advantages to others intending to obtain or retain business or an advantage in the conduct of business for Airbus, and that Those financial advantages were intended to reward such improper performance, and further that Airbus did not prevent or have in place at the material times adequate procedures designed to prevent those persons associated with Airbus from carrying out such conduct. That should be enough.
That shouldn't be enough. I want 4.5.
You can summarize, or because of time.
I'm taking you to a place where they say Airbus admitted. That is why so that we.
So it's not in doubt. So
it's
can
not
we
in
go
doubt.
on? Yeah, it's not in doubt.
All right.
Yeah.
So in conclusion, I will say that the fact that you did not find direct evidence of money having passed from Samuel Adam Mahama physically, but Airbus admitting that indeed and in fact he gave money to Samuel Adam Mahama
as agency fees.
No, they never said as agency fees. They have given him money.
Okay, so we avoid the controversy. Can I read for you? 4.5. Okay. In respect of Ghana, Airbus was charged with the offense of failure of a commercial organization to prevent bribery. Contrary to Section 7 of the Bribery Act 2010, the particulars of offense stated that between 1st July 2011 and 1st June 2015, Airbus failed to prevent persons associated with Airbus from bribing others concerned with the purchase of military transport aircraft by the government of Ghana, where the said bribery was intended to obtain or retain business or advantage in the conduct of business for Airbus.
And my last two, 4.39 and 4.4.
So something you see that where you just read.
4.39.
11. They are talking about 2011 also.
Yes.
Payments from Airbus to Samuel Adam Mahama started in 2012 and ended in 2014.
So let me do this. The portion he wants me to read, there are portions I have already highlighted, and the last two he's asking for, they are very short.
Very short.
So 4.39, Airbus admitted, accepted, and acknowledged that it was responsible under U.S. law for the acts of its officers, directors, employees, and agents as charged in the DPA, and that the allegations described in the DPA are true and accurate. 4.40, is that it?
Yes, last one, the last one.
Airbus also accepted that the facts were established beyond reasonable doubt and that the facts took place during the relevant time frame.
So in conclusion, Airbus accepted that in fact...
Airbus paid 1.13 billion or so.
The allegations as contained in a relevant period against its officers, including Samuel Adam Mahama, were in fact true and accurate and was proved beyond reasonable doubt. I end my story.
Okay.
That's your view.
Yes.
That is what's captured here.
That's your view.
No, it's not his view. It's what is captured.
Yes. No.
But again...
in relation to Ghana and our special...
No, you don't need to do that. We have established the principle of law that when you are doing these things, you will agree to these things, but the agreeing to them does not necessarily mean that they in fact are what they are.
That's what I'm... Yeah. That's what I... Yeah.
Mr. Vice Azim, we end with you. So do you suspect that... Okay, I understand we have lost Mr. Azim. I was going to ask him if he thinks that there should be a further process in respect of conflict of interest, regardless of whether or not John Mahama is not in public office now. Dr. Kojo Pumpuni Asante says that I agree with the report, particularly the observations on conflict of interest. I think the OSP could have referred further to the SHRAJ guidelines on conflict of interest published in 2006 to draw attention to failure of the former president to cure the conflict of interest situation he found himself. As soon as he became aware of the potential conflict of interest situation, he had to remove himself from the transaction. As the OSP said, his decision to persist, motivated by his good intentions to secure a good deal, was not the right way to deal with. That situation cannot pass the appearance test or the smell test and unnecessarily expose the transaction to suspicion of corruption. He agrees with Gary that this is the situation we have. It's difficult to prove corruption by direct processes. We take a quick break. We'll be right back